with the intervention, the written intervention of Professor Roberto Andorno, Associate Professor of Bioethics and Biomedical Law at University of Zurich in Switzerland. Professor Andorno was not able to attend in person. That's why my dear colleague Teresa Gens will read his intervention.
So I'm going to read the speech of Roberto Adorno on the need for a ban on surrogacy at international level. Today, it's widely accepted that it's morally and legally wrong to treat individuals as mere objects. Since the abolition of slavery and the establishment of universal human rights, every person is recognized by law as someone, and not just as something that can be bought and sold. As a result, modern legal systems consistently reject any practice that blurs the distinction between persons and things, subjects and objects. This clear differentiation must remain a fundamental principle of democratic legal systems and international human rights law. What ultimately is at stake here is the principle of respect for human dignity, which means that every human being has inherent value. Unfortunately, the possibility of creating human embryos in vitro has opened the door to new forms of commodification of human beings over the past few decades. One of them is surrogate motherhood, or surrogacy, as we know. Domestic laws give disparate responses to this practice. For instance, most countries in Western Europe explicitly prohibit surrogacy on the grounds that it's degrading and exploitative of vulnerable women, and it's also contrary to the best interest of the child, as children conceived under such agreements are to some extent reduced to the condition of a merchandise that can be bought and sold. In this regard, Switzerland decided at the end of the 90s to enshrine the ban on surrogacy in its constitution, which provides that all forms of surrogate motherhood are illegal, Article 119 of the Constitution. Consistently, in the explanatory report to the Swiss law on medically assisted reproduction, this ban is justified on the grounds that the practice of surrogacy instrumentalizes the woman and is contrary to the interest of the child. However, so far, there are no specific provisions in international law that explicitly prohibiting intercountry surrogacy. This practice has expanded globally over the past 2 or 3 decades due to the inaction of the international community, which has not been able to respond satisfactorily to this concerning phenomenon. It is worth mentioning that when faced with other similar forms of human exploitation and trafficking, such as organ selling and human trafficking for forced labor or sexual exploitation, international law did react and adopt legal measures to prevent those practices. In contrast, it has remained strangely silent regarding the exploitation of vulnerable women and the trafficking of babies that involve the practice of intercountry surrogacy. It is time to change course and take effective global action in this area. The problem is the disparity of domestic laws on this matter, and the simple absence of domestic regulations prohibiting surrogacy that does not facilitate that task. Over the past 2 decades, this disparity or the lack of regulation has led to the emergence of a global market for surrogacy. People from all over the world who are looking for surrogate mothers travel to some destinations to obtain a baby in exchange for money. This global market moves constantly, and new destinations emerge regularly as a result of changes in domestic laws. In addition, the prohibition of surrogacy in some countries, such as those from Western Europe, is difficult to implement when the intended parents go abroad to circumvent the national laws and then bring home a baby born on the surrogacy agreement. In such cases, national courts are confronted with the fait accompli and tend to recognize parental rights to the intended parents, even if they have circumvented national law. Moreover, national courts in Europe are under pressure from the jurisprudence of the European Court of Human Rights, which obliges them to recognize the effects of surrogacy agreements made abroad. Paradoxically, because the European Court decisions are based on the principle of the best interest of the child, the same principle that is invoked by national states to prohibit surrogacy. The argument is that depriving those children of legal parentage with intended parents would be contrary to this principle. It seems clear that a multilateral, comprehensive approach to this matter is needed. And some experts suggest developing a legally binding instrument that at least prohibits commercial surrogacy, which represents the great majority of cases of this practice. Such a convention would be inspired by the Hague Convention on Inter-Country Adoptions of 1993. Let us remember that this convention requires that the consent of the family of origin has not been induced by payment or compensation of any kind, and that the consent of the mother has been given only after the birth of the child. Article 4. Similar provisions in an international agreement on surrogacy, if effectively implemented, would drastically reduce this practice. However, it is dubious that developing such a convention would be feasible in short term. The discussions carried out by the experts group of the Hague Conference on Private International Law since at least 2016 show well the serious difficulties of reaching consensus on this matter, given the disparities between domestic laws. If adopting a convention banning surrogacy proves to be impossible in short term, then an alternative and probably more realistic option would be to create a soft law instrument, such as a declaration, within the framework of the United Nations system. Such an instrument could be the first step toward a convention in the long term. In addition, the adoption of a declaration would present two important advantages. First, it would encourage countries to gradually become familiar with the reasons for a ban on surrogacy before they decide to adopt domestic binding rules prohibiting surrogacy. And second, it will provide immediate evidence of international consensus rather than a convention whose impact may be heavily diluted by reservations and the need to wait for a years-long ratification process. Let us remember that soft law agreements differ from treaties in that they do not require formal ratification by states, and therefore can have a more direct and more rapid influence on the practice of states than treaties. In the meantime, it is also possible, and even easier in the immediate term, to reach bilateral agreements between countries that prohibit surrogacy and those allowing it. For instance, those agreements could restrict access to surrogate mothers to citizens from those countries in which the practice is prohibited. In fact, this already happened a decade ago between some European countries and India, and afterward led to change in Indian legislation, requiring foreign couples to prove that surrogacy is legal in their countries. Later on, the Indian law became more restrictive, completely forbidding all foreign couples from having access to surrogate mothers in the country. Even more recently, in 2024, a new change in Indian law has banned altogether commercial surrogacy and only allow altruistic surrogacy. In conclusion, from a perspective of international human rights law, it is perfectly arguable that inter-country surrogacy must be banned, on the grounds that it amounts to the sale of children and is exploitative of vulnerable women. There is a need for multilateral agreement on this issue and for prohibiting at least the practice of commercial surrogacy. If adopting a binding instrument banning surrogacy proves impossible in the immediate term, an alternative would be to adopt a soft law instrument, such as a declaration, which would become the first step toward a binding instrument. In the meantime, bilateral agreements between countries can also play an important role in this process.